Right, well, I think we'll make a start. Hello, everybody, and welcome to the first of Quadrant's two-part series on the consequences of Brexit. Not, sadly, the finer points of sausage tariffs today, but questions of a more practical nature to commercial dispute resolution. Where does the UK's withdrawal from the European Union leave us in terms of two crucial issues? First, the applicable rules on jurisdiction when you're pursuing a defendant in an EU member state. And second, the recognition and enforcement of judgments between the UK and member states. Today, our panel, Simon Rainey QC, Rob Thomas QC, Andrew Leung, and myself are going to look at the first topic of jurisdiction. Next week, at the same time, same place, we're going to look at how the rules on recognition and enforcement of judgments, both here and within the EU, have changed. We are also going to look at a couple of case studies to see how the changes on jurisdiction and enforcement might play out in practice. Now, if you do have any questions on jurisdiction, then please do write them into the Q&A function, not the chat function, please, and we will do our best to answer them during today's session. Given that we are recording this session, if you prefer your name not to be read out, recorded for posterity on YouTube, then please do post anonymously. So today, in particular, we're going to look at four questions. Firstly, which rules have gone? Secondly, what rules replace them or fill in any gaps? Thirdly, how does one go about serving out of the jurisdiction now? And finally, anti-suit injunctions and parallel proceedings, which are both now back on the agenda for intra-EU matters. So, getting stuck straight in, what has gone? Well, I've set out there on the slide the relevant instruments which will no longer apply in the UK after the 1st of January 2021. The crucial one is the fact that the UK is no longer party to the Brussels Recast regulation. So the rules contained in that regulation and its predecessors for taking jurisdiction over defendants are no longer part of UK law. But do note, it still applies to any legal proceedings started before the 31st of December 2020. So there will probably be a period of a few years where you will still need to be mindful of the old rules. So where do we look instead? Well, firstly, I think probably most relevantly for commercial practice, it is the 2005 Hague Convention on Choice of Court Agreements. That will step up to fill some of the gaps, and we're going to go on and look at the detail this morning. Secondly, you have the common law rules on jurisdiction, which have always been applied to non-EU domiciled defendants. They will now apply to EU defendants as well. Now, despite much optimistic ink having been spilt on the topic of the Lugano Convention, which contains broadly similar rules to the Brussels regime, the UK's application to join the Lugano Convention was formally opposed by the EU Commission very recently on the 4th of May. So whilst the UK's application will now go to the European Council, I think in light of the Commission's reasoning in opposing the application, we shouldn't be holding our breath that we're going to accede to that particular convention anytime soon. So looking first at an overview of the Hague Convention, the purpose of this convention, not to be confused with the Hague Service Convention, is to ensure the effectiveness of a choice of court or jurisdiction agreement between parties to international commercial transactions. The UK acceded to the convention on the 1st of October 2015 as an EU member state, and then independently on the 1st of January of this year. And as we shall hear from Simon, there's a question mark there as to the date from which it applies. The signatories to the Hague Convention are currently the EU, its member states, Singapore, Mexico, and Montenegro. But the hope is certainly that in time you will have far more signatories and those who ratify in the manner of the New York Convention on Arbitration. So the Hague Convention contains three basic rules that give effect to choice of court agreements. It is in many ways very simple. So firstly, the chosen court must in principle hear the case. Any court not chosen must in principle decline to hear the case. And finally, any judgment rendered by the chosen court must be recognised and enforced in other contracting states, except where there are a small number of listed grounds for refusal. Now, the Hague Convention, as I said, set out quite simple criteria for its application, but I think it's fair to say that it lacks the refinement and nuance of either the Brussels regime or the common law rules. As an international convention, the drafters were keen that a non-domestic approach be taken to its interpretation. So by Article 23 of the Convention, a uniform interpretation is mandated, with courts being required to have regard to the international character of the Convention and to the need for uniformity. So I think until we have more cases, we simply aren't going to know how much the English courts will have regard to the decisions of other contracting states. But given that the Court of Justice of the European Union will make binding decisions, at least on behalf of the 27 remaining member states, I think it's probably right to say that decisions of the European Court will still play a role in the jurisprudence of this country, at least as regards conflicts of laws. And for additional help in terms of interpretation, there is a report on the articles of the Convention and the intention of the drafters, the Hartley-Dogauke report, which will no doubt be helpful to refer to. So to what does it apply? Well, it applies to a choice of court agreements or jurisdiction agreements, as we often call them, concluded in civil or commercial matters in international cases. By international cases, what is meant is those where the parties are resident in the same state and all of the elements relative to the dispute are in that state as well. So those don't fall within the scope of the Hague Convention. Importantly, and in a unique approach, it applies only to exclusive choice of court agreements, which means that in order to qualify, the clause must designate the courts of one contracting state to determine disputes arising out of a particular legal relationship, to the exclusion of all others. So that means that a clause stating that the parties must resolve their disputes in state X, the emphasis there being on the word must. A clause in permissive language, for example, the parties may resolve their disputes in state Y, is not exclusive. Practically speaking, Article 3b, which I've set out on the slide there, is going to be very important, I think, because its effect is to deem that an agreement will be exclusive or will be treated as exclusive for the purpose of the Convention, unless the parties expressly provide that it is not. Or the language which they through the language which they use to allocate jurisdiction. The practical effect, I think, of that will be that it is only where the parties have made it clear that there is an intention to be non-exclusive that the Hague Convention criterion won't be satisfied. So I think any ambiguity will be resolved in favour of deeming exclusivity because of the need for express choice of non-exclusivity. The choice of court agreement must also be concluded or documented in writing, which for most of the work that we do will be the case, but it's also possible that it can be rendered in any other form of communication, which enables it to the agreement to be usable for subsequent reference. In other words, there has to be a durable record of the agreement. So, assuming that a court can take jurisdiction under the Hague Convention, what must it do? Well, the rule under Article 5 is very simple. Where a court has jurisdiction by an exclusive choice of court agreement, it must take jurisdiction. And apparently, according to the words of Article 5, no discretion is offered to the court. Now, that gives rise to obvious problems. For example, what if parallel or related proceedings are already underway in another convention state? It appears by Article 5 that nevertheless the chosen court must get on with it. The flexibility of the Brussels regime, or indeed the common law rules, well, the common law rules don't apply here, but the flexibility of the Brussels regime has gone. And Article 5.2 provides that the chosen court must not decline to exercise jurisdiction on the ground that the dispute should be decided in a court of another member state. Now, Article 5.1 requires the dispute to be one to which the choice of court agreement applies. But then the question arises, well, which law decides that? Now, the Convention is silent on this point, as it is silent on many points. But I think it is likely that here the usual English conflict of laws rules will apply, i.e. that's the law that governs the choice of court agreement, which is usually that law that governs the contract, that will answer the question of whether or not the dispute falls within the scope of the choice of court agreement. And finally, one point to note, there is a ground upon which the chosen court can decline jurisdiction, and that's where it finds that the choice of court agreement is null and void under the law of the chosen state. Now, that is a quite major departure from the usual position under English conflict of laws, which would normally look to the putative law of the agreement to answer that question. So what must other courts do? Well, under Article 6, the court of a contracting state whose jurisdiction has not been chosen must suspend or dismiss proceedings to which an exclusive choice of court agreement applies. And again, there is no discretion. There are 5 limited exceptions to the rule, which I've set out on the slide, but those are likely to be interpreted narrowly. So in summary, we are now in a somewhat simplified world when it comes to choice of court agreements. And I've set out there on the slide what I hope is a useful checklist of the boxes one has to tick to come within the Hague Convention. But inevitably, there will be wrinkles. So I'm now going to hand over to Simon Rainey, who is going to explore 3 vexed questions which we may well need to grapple with when relying upon the Hague Convention.
Good morning, ladies and gentlemen, and it's very, very nice for so many of you to have joined us. So as Gemma said, I'm going to be dealing with navigating the limits of the scope of application of the Hague Convention 2005. And I want to consider, in the short space allocated to me, 3 questions. First of all, the Convention applies to contracts made when? That's the temporal question, which Gemma touched on a little earlier. Secondly, to what matters will it apply and to what matters won't it apply? And I think there are some surprises there for us all. And thirdly, building on what Gemma's been talking about a little earlier, what happens if you've got a rather odd type of jurisdiction clause, which is not that uncommon? And the question there is, what sort of jurisdiction clauses actually meet the requirement of an exclusive choice of court under Article 3? So let me deal with the first question, to contracts made when. The picture I put up here is what can only be described as a very boosterish document. This is the guidance for legal professionals issued by the Ministry of Justice in full Boris Johnson, there will be no problems mode, with a very optimistic view of a lot of matters. It makes for very entertaining reading, I can tell you. But the question which comes up, and it's going to be a question which is going to have to be grappled with not only by English courts, but also by foreign courts when you're seeking to rely upon the convention in front of them, is when does the convention actually apply as between the United Kingdom and individual member states of the European Union? The problem comes around because of Article 16.1, which says this convention shall apply to exclusive choice of court agreements concluded after its entry into force for the state of the chosen court. So when did this convention enter into force? Well, we were members of the EU, as you may remember, until last year. The EU and all member states, including the United Kingdom, acceded to the convention as long ago as the 1st of October 2015. But when we come out of the EU, does that make a difference? The United Kingdom plainly wanted to ensure that it didn't make a difference. And so on the 28th of September, it deposited an accession instrument so that it enters into force again, as it were, on the 1st of January 2021. The reason it has done this is because the EU Commission's view, and I think we can see which way it's going after the opposition to us rejoining Lugano, was that the 2005 Convention only enters into force between the EU and its member states and the UK upon the United Kingdom becoming a party as an independent state, not as a member state, to the 2005 Convention, so only from the 1st of January 2021. The United Kingdom view, in that rather boosterish document I just showed you, was, oh, there are no problems. The 2005 Convention has continued to apply without interruption from the original entry into force on the 1st of October 2015, and all that's happened with the later accession was a belt and braces exercise. There's the UK Ministry of Justice guidance, and we made a declaration, probably more optimistic than real, when we accompanied we deposited our instrument of accession. Interestingly, an independent view, and this is the only first independent view because we don't know what the English court thinks about what the position is, and we certainly don't know what EU member state individual courts are, the court in Graz, the court in Rome, the court in Nîmes. What view are they going to take? Are they really going to be very interested in the United Kingdom guidance note? I doubt it. Though they might be much more interested in this. This is the view of the Hague Conference on Private International Law, which looks after as it were, the conventions and ratifications. And that states that the Convention entered into force for the UK in 2015. And so the UK was bound by virtue of the approval of the EU, and that the new instruments of accession and ratification ensure continuity. But they did unhelpfully then say that the Convention will continue to be applicable until the 31st of December 2020, and then the Convention will enter into force again on the 1st of January 2021. So a whole host of potential problems there as to when the Convention actually applies as between the United Kingdom and a member state of the EU. Same problem doesn't arise, and possibly in relation to Singapore and Montenegro. That's the first vexed question. The second vexed question are exclusions and inclusions. Are you in or are you out of the Hague Convention? And I think this will come as a bit of a surprise to those that haven't looked at the Hague Convention. I put up on the left-hand side of the slide the good old days, if I can call them that. Article 1.2 of the Brussels Recast, very, very few exceptions to the scope rationia materiae of the Convention. Matrimonial, testamentary, bankruptcy, social security, arbitration. On the right-hand side, all of those are mirrored in Article 2 of the Hague Convention, but there is a much longer list. So claims for personal injury, tort claims, perhaps that's not quite so unsurprisingly, but they don't arise from a contractual relationship, but rights in immovable property, intellectual property rights, and infringement of intellectual property rights are all outside the scope of the Convention. And for those of us that practice in commercial work on the international trade and shipping side, there is a big shock, because all of that I have on the slide here is excluded. And what I mean by that is Article 2.2f excludes entirely from the scope of the Convention the carriage of passengers and goods. The explanatory report, which is essential reading for anyone considering the Hague Convention, explains the reasoning for this, which is pretty curious, I would suggest, as being the exclusion is necessary because for carriage by sea, land or air, or any combination of the three, because these carriages of persons and goods are subject to a number of other conventions, for example, the Hague Rules on bills of lading, and they might have given the example of the Warsaw Convention for air travel. By excluding these matters, the possibility of a conflict of conventions is avoided. But the odd thing about that is there could be no conflict of conventions, because take the Hague Rules as an example. They say absolutely nothing about a jurisdiction. They say absolutely nothing about enforcement. They say absolutely nothing about the matters which the Hague Convention is dealing with. But for those of us that do shipping work, and I noticed from the list of participants there's a lot of us on the line, as it were, maritime matters are also subject to another further exclusion in G, pollution, limitation of liability, general average, and emergency towage and salvage. And I've set out paragraph 59 of the explanatory report there. But note the text which I've highlighted in red. Other maritime shipping matters, for example, marine insurance, non-emergency towage and salvage, I'm not really sure I know what non-emergency salvage is, shipbuilding, ship mortgages and liens are included. And footnote 30 refers to a previous paragraph in the explanatory notes, which says and stresses other areas of shipping law are covered. We're going to be dealing with test cases, as Gemma said, next week, and some examples. But here's an interesting one for you, a nice question to arise under the Convention. Here is a non-emergency tow, so arguably already within the Convention. If the barge is owned by the tug owner, and therefore the goods which are on it are being carried by the barge, then that contract will be outside the Convention. If, however, the barge is provided by the person who owns the goods, who wants them towed from A to B, then it will be within the Convention. Interesting questions like that are no doubt coming our way. Lastly, on inclusions and exclusions, insurance contracts. Article 17 is important. We've already seen that contracts of marine insurance are specifically included, but Article 17 includes all contracts of insurance, and that is so irrespective of whether the risk underwritten in the particular contract of insurance is something which is excluded. So take, for example, an insurance policy which underwrites personal injury risks and death risks. As we've seen, claims for personal injury are outside the scope of the Convention, but the insurance isn't, because all insurance, whether or not it relates to a matter to which the convention applies or not, will be covered. So insurance is in, as it were, in a big way. So those are the inclusions and exclusions. So far we've covered temporal application, with a problem there. I think the very clear rules, despite my little example, of what's in and what's out. The last issue I wanted to consider is your jurisdiction clause. Does it actually fit what Gemma has described as the requirement under Article 3 for an exclusive jurisdiction clause? As Gemma mentioned, it must be a mandatory, so it must say you will or you must, disputes must be submitted to the court, the jurisdiction of Court A. If it says may, it's not sufficiently mandatory. But there are other problems, and one of the other problems is the problem of asymmetric jurisdiction clauses, which one finds particularly in financing agreements and other types of financial instrument. Here is a jokey picture of a Venn diagram of an asymmetric jurisdiction clause. But for a real one, which came up very recently in the courts last year, here's the clause that the court had to consider in Etihad Airways and Floater. The courts of England have exclusive jurisdiction to settle any dispute arising out of or in connection with this agreement. That looks pretty clear, doesn't it, ladies and gentlemen? The parties agree that the courts of England are the most appropriate and convenient courts to settle disputes. Well, that gets rid of foreign convenience arguments, and that too looks pretty clear, doesn't it? And then 33.1.3 in the particular contract, this clause 33 is for the benefit of the lender only. As a result, the lender shall not be prevented from taking proceedings relating to a dispute in any other courts with jurisdiction. So it's exclusive one way, but it's not exclusive the other way. Your test question, within or without Article 3 as an exclusive jurisdiction clause? Well, you'd be entirely accepted if you took a view either way, because the courts have. I'm not sure the weather vane has come to a final rest, but I think the settled direction is definitely westerly, looking at this weather vane. Here are two first instance views. Mr. Justice Cranston in Commerce Bank and Liquimar, good arguments in my view that the words of the definition of exclusive jurisdictions cover asymmetric jurisdiction clauses, but he didn't need to decide. The subsequent case, in 2019, Mr. Justice Jacobs in Etihad Airways and Floater said, like Mr. Justice Cranston and Merit, which is an academic article, I consider there are good arguments that the rules in the Hague Convention are engaged by an asymmetric clause. Etihad went up to the Court of Appeal, and the Court of Appeal did not have to express a concluded view, but I think this is where we now are. And it's worth considering it just a little in a minute or two. The Court of Appeal said that they were prepared to proceed on the basis that the Hague Convention should probably be interpreted as not apply to asymmetric jurisdiction clauses. Again, they didn't decide the point, so the point is technically open. But I think that even if the door is technically open, I think that the Court of Appeal have definitely put their foot on the other side, because they referred to two rather powerful pointers to the fact that asymmetric clauses are not within the Convention. First of all, the explanatory report of Professor Hartley and Professor Dagauki, who in their discussion said that it was agreed by the diplomatic session that the agreement must be exclusive, irrespective of the party bringing the proceedings. So agreements of the kind referred to in the previous paragraph are not exclusive choice of court agreements for the purposes of the Convention. That, I think, is pretty powerful by itself. But the Court of Appeal went on to refer to the diplomatic minutes of the meeting of 2005, so effectively the travaux préparatoire, if you like, of the Hague Convention. And they said this: the minutes show that the proposal by the Swiss delegate to amend our existing definition of an exclusive choice of court agreement so as to make it clear that it included asymmetric jurisdiction agreements by inserting the words for some or all of the parties' agreement was debated but found no support. The amendment was then withdrawn. And in English terms, we all have in English cases to look at bullseyes when we're looking at travaux préparatoire, as the House of Lords has told us. That looks very much like a bullseye or treble top to me. So thank you very much indeed for your attention on those next topics. I stop sharing now, and I'm now going to hand over to Rob Thomas. When I asked Rob what his talk was about, he said it's about something dull but important. Well, it'll never be dull because Rob Thomas is giving the talk. But it is definitely important. What Rob's going to be talking about is service out of the jurisdiction post-Brexit and the changes that have been made to the CPR and how we look at the CPR now post-Brexit for service out, both with and without permission. And that's going to be an everyday topic. So over to you, Rob.
After all the tricky questions he's answered, I have the rather more mundane task of summarising the practical changes in terms of service out of the jurisdiction. As I'm sure you'll all be aware, for many years, Part 633(1) provided that permission to serve out of the jurisdiction was not required where the court had jurisdiction under the Lugano and then the Brussels Convention. That, of course, meant that from a practical point of view, cases involving an EU defendant didn't raise the need for permission to permission to serve out of the jurisdiction. Now, that provision has now been deleted. So where does it leave us in cases which formerly fell or would have been covered by the Brussels regulations? Well, as a matter of overview, it's useful to remember the basic position remains the same in the UK, namely there's no right to serve proceedings out of the jurisdiction unless the rules provide that you may do so. Likewise, the basic structure of the rules remains the same in that they identify those occasions where the claim form may be served out of the jurisdiction without permission, as well as those occasions where permission is required. So far, so easy, but with the removal of the previous Part 633(1), when is service out of the jurisdiction now possible without permission? The answer to that question can be found in the revised Part 6.33(2), and that essentially provides for service out without permission in 4 different contexts, which I've summarised on this slide. Under the revised provisions of the CJJA 1982 in relation to consumer and employment matters, under the 2005 Hague Convention, of which we've heard quite a lot already, and from the 6th of April, pursuant to a contract term conferring jurisdiction on the English courts, and finally under other legislation. Now, in and of itself, that summary probably doesn't tell you very much, so I'm going to deal with each of these briefly in turn. First of all, the revised CJJA to a large degree reflects some of the provisions of the Brussels Recast regulations and provides protection essentially to individuals in consumer contracts and individual contracts of employment. The actual amendments to the Act are quite lengthy and we don't have time to deal with those, but I've put on the screen what the new Rule 633(2) actually provides. And as I said, it essentially provides a degree of protection for disadvantaged people, local claimant consumers suing a foreign professional, for example, or local working employees suing a foreign employer. It's interesting to note in passing that they are actually substantially more beneficial than the provisions of the Lugano Convention. So if we end up actually acceding to the Lugano Convention, I can only assume that these provisions will have to be revoked. Moving on, and probably of much more interest to those on this particular session, are the 2 provisions which relate to choice of court clauses. Now, the new subparagraph 2b in Rule 633 provides a set out, and essentially it permits service without permission in 2 cases where the court has power to determine that claim under the 205 Hague Convention and the defendant is a party to an exclusive choice of court agreement within Article 3 of that convention, or where there's a contract term which is to the effect that the court shall have jurisdiction to determine that claim. Now, self-evidently, the rule is split into 2 parts, and whilst at first the relevance of the distinction may not be obvious, whether a case falls within the Hague Convention will be relevant, at least in the following contexts. First, in the context of enforcement, which we will be dealing with next week, and also because the Hague Convention contains a rather mechanical provision requiring other signatories to decline jurisdiction. So to look at these new provisions in brief, Article 5 of the Hague Convention, I think we've already seen, but effectively confers jurisdiction on the court or courts of a contracting state designated an exclusive choice of court agreement. Now, as we've also touched upon, the definition of exclusive choice of court agreements is governed or set out in Article 3, and the essential words are that an exclusive choice of court agreement means an agreement that designates for the purposes of deciding disputes the courts of one contracting state to the exclusion of the jurisdiction of any other courts. The takeaway from that is that in addition to the formal requirements in subparagraphs C, as Simon and I think Gemma have both described, the Convention will only apply where the relevant clause is one that identifies a single forum for all disputes. The explanatory report to the Hague Convention confirms that asymmetric or hybrid jurisdiction clauses are not exclusive choice of court clauses, as Simon has already explained. And indeed, I've put on the screen the one example that report gives, which is international loan agreements, which very often have an asymmetric jurisdiction clause within them. So that's the convention. It brings us on to subclause B, which, as I've said, was amended with effect from the 6th of April 2021 to remove the need for the court's permission to serve the claim form out of the jurisdiction where there's a jurisdiction clause in favour of the English courts, even if that jurisdiction clause does not fall within the 2005 convention. And as we'll see shortly, the relevant paragraph or subparagraph of part 6.36, which previously permitted service out of the jurisdiction with permission if there was a jurisdiction clause, has consequently been removed from that rule. Now, given not only the issue just discussed as the requirement for there to be an exclusive choice of court agreement, but also the exclusions of contracts for the carriage of goods, as well as certain other maritime matters from the scope of the Hague Convention, which Simon discussed, this provision is, I think, likely to be of considerable importance in the sort of commercial work that I suspect most of us do. And in this regard, when interpreting it, the White Book commentary has noted that the old authorities under part 6.36 are likely to remain relevant. But you'll note that the wording is certainly not the same as that provision, and indeed is very wide. It's, I think, anybody's guess as to what might fall within the wording, a term to the effect that the court shall have jurisdiction. That seems to me to be a deliberately broad term, the precise scope of which is yet to be worked out or determined. So that is the key provision, I think, from our perspective. Just to sweep up, you have the fourth category where permission is not required, and that's where the court has power to determine a dispute other than under the 2005 Hague Convention. In practical terms, that's where other legislation specifically provides for this to be the case. So those are the new rules on service without permission. But what if your claim against an EU defendant does not fall with one of the categories that I've just described? Well, the sweeping away of the Brussels regulations and the absence of the Lugano Convention means that we fall back on the existing rules as to service out with permission. Now, those, as I'm sure you'll all be aware, are covered by part 6.36, which cross-refers to paragraph 3.1 of the relevant practice direction. And I've summarised on the screen the main, but certainly not all of the provisions, the heads of jurisdiction, which fall under that sub-paragraph. And as I've already mentioned, notable by its absence in light of the amendments to the provisions governing service without permission is any reference to contracts containing a jurisdiction clause in favour of England. Otherwise, the list remains unchanged. So that's service out with permission. Just drawing the strands together, what's the overall effect? Well, the first is this, in my view at least. Concerning the taking of jurisdiction in general, the differences are arguably more superficial than substantial. It's not easy to think of a case, and certainly not many cases, in which the English courts would have jurisdiction under the Lugano Convention, or the Brussels regulations for that matter, but would not be able to establish it under the rules as they now are. Indeed, in some respects, the position now is broader. In particular, rules for taking jurisdiction over co-defendants in the Lugano Convention in particular are inconveniently restrictive. and the common law rules providing for jurisdiction over proper parties are certainly broader and arguably more flexible. So the overall result seems to me to be that whilst the rules look different, there will be very little loss of jurisdiction or access to jurisdiction, and quite possibly a widening of it. Secondly, and importantly, forum non conveniens arguments are back on the table for disputes with EU-based defendants. That, of course, follows from the simple fact that if you don't fall within a limited category where no permission is required, any case falling under CPR Part 6.36 in the practice direction is subject to that overriding requirement. So those arguments will, I'm sure, come back into vogue. Thirdly, there is, of course, a risk to UK companies of being sued in the EU. The effect of revoking the Brussels regulations, of course, is that the English defendant loses the basic privilege of being sued in his home country. But at the same time, what is sauce for the goose is sauce for the gander, and the same will be true for those domiciled in member states of the EU. Indeed, as Professor Adrian Briggs rather memorably says in his new book, or the new edition of his book, with the common law and civil procedure rules, English jurisdiction has longer arms and many of them. And very briefly, just before I hand over to Andrew, touching upon the issue of how is service to be affected. Of course, the EU service regulation is out, and back in, at least for EU countries, is the Hague Service Convention 1965, not to be confused with the 2005 convention. Now, time doesn't allow me to develop much more on that, but what is important to note is that it is prescriptive, and the CPR specifically confirms that no order of the English court can be taken to authorise or direct the doing of anything contrary to the law of the state where the service is to be affected. So it is important to comply with that convention and also to understand local requirements. And this may well add a layer of additional investigation with local lawyers in the relevant jurisdictions. That said, and my parting remark is certainly the reality of this is that the mechanisms for service of process and the taking of evidence in European states will be downgraded. I don't think there's any doubt that the Hague Convention doesn't do as good a job as the revoked regulations, and that's an undoubted loss. So on that sobering note, I will unshare my screen and I will pass over to Andrew, who's going to talk about the altogether more sexy topic of anti-suit injunctions. Andrew.
Thank you, Rob. I didn't think your bit was dull at all. I'm not sure my bit's going to be sexy, though. So I'm going to be talking about anti-suit injunctions and parallel proceedings. Let's start with the pre-Brexit position. As a matter of English law, an anti-suit injunction restrains a person over whom the court has jurisdiction from bringing foreign proceedings. However, the European Court has long regarded anti-suit relief as an impermissible device by which the English court tells a foreign court, if only indirectly, that it should not exercise its jurisdiction. Anti-suit injunctions are therefore prohibited in the EU context. Two cases illustrate the European Court's approach. In Turner and Grovet, the European Court held that the then applicable Brussels Convention precluded the grant of anti-suit injunctions. And this was because anti-suit relief interfered with the foreign court's jurisdiction and was contrary to the principle of mutual trust, which prevents one court from reviewing the jurisdiction of the court of another member state. The hostility of the European Court to anti-suit injunctions was such that in the front Comor, the European Court put an end to the use of anti-suit injunctions to restrain proceedings brought in breach of arbitration agreements, using similar reasoning to that in Turner and Grovet. This result surprised many commentators, given the arbitration exception in the then applicable Brussels regulation. Indeed, in the Gazprom case, the Advocate General went out of his way to conclude that the Recast regulation, which contains a reinforced arbitration exception, had the effects of reversing the front Comor. But the European Court wasn't interested in this and didn't adopt the Advocate General's reasoning. So back in this jurisdiction, it was held in Norrie Holdings that there is nothing in the Recast regulation which undermines the European Court's decision in the front Comor. So much for the position pre-Brexit. Where are we now? Well, we're no longer shackled by the Brussels regime or the comparable Lugano regime, which signals the revival of anti-suit injunctions in the EU and EFTA contexts. The common law once again applies with the same force as it does in relation to any other foreign proceedings, complemented by the Hague Convention where applicable. So we're back in the position where an anti-suit injunction will be granted to restrain foreign proceedings which breach an exclusive jurisdiction or arbitration clause, unless there are strong reasons not to do so. The other ground is where the foreign proceedings are vexatious or oppressive. The UK has acceded to the Hague Convention on choice of court agreements in its own right. This prompts the question whether the Hague Convention imposes any restrictions on the grant of anti-suit relief. Let's say an anti-suit injunction is sought to restrain proceedings brought in breach of an English exclusive jurisdiction clause before the courts of another Hague Convention signatory, for example, Singapore. Under Article 6, the court not chosen shall, subject to certain exceptions, suspend or dismiss proceedings to which an exclusive choice of court agreement applies. This is not dissimilar at first sight to the principle under the Brussels-Lugano regime, whereby the foreign court should be left to assess its own jurisdiction. So, following the reasoning in Turner and Grobbett, an argument could be made that a court's exercise of jurisdiction is self-regulating, and that it is exclusively for the Singaporean court to decide whether proceedings should be stopped. However, Article 7 of the Convention provides that interim protective measures are not governed by the Convention. And this appears to rule out any arguments that an interim anti-suit injunction would be precluded. If that's right, it would be rather curious if a final anti-suit injunction were precluded by the Convention. Second, it seems unlikely that the reasoning in Turner and Grobbett or the philosophy of the Brussels regime can be transposed to the Hague Convention. In Etihad and Flotter, a case we looked at with Simon, the Court of Appeal noted that the Hague Convention is an international agreement which should be construed according to principles of international law and is not subject to the jurisprudence of the European Court. Third, Professor Hartley, in his book, Choice of Court Agreements, suggests that the Hague Convention is neutral as to whether anti-suit injunctions are permitted, while Professor Briggs, in the new edition of his book, Civil Jurisdiction and Judgment, makes a pragmatic prediction that the English courts will grant anti-suit injunctions restraining proceedings in Hague Convention states, which are brought in breach of English jurisdiction clauses, until the Court of Appeal or Supreme Court holds that this is incompatible with the Convention. The next question is whether anti-suit injunctions are likely to be effective within the EU. If member state courts give such injunctions short shrift and refuse enforcement, a topic to which we'll return during the next session, that would be bad news for English practitioners. But there is some reason to suppose that the traditional aversion on the continent to anti-suit injunctions has softened. One encouraging sign is the ruling of the French court in Zonebrand, a 2009 decision, where the court concluded that an American anti-suit injunction should be recognized and enforced in France. The court pointed out that this did not violate the respondent's right to a fair trial under Article 6 of the European Court of Human Rights, and was not contrary to public policy, as the American court, which had issued the anti-suit, was ruling on its own jurisdiction and enforcing the parties' choice of court agreement. The French court therefore accepted the legitimacy of anti-suit injunctions in principle. More recently, the higher regional court in Munich granted the first anti-suit injunction in German history, i.e. an order restraining the pursuit of an anti-suit injunction. In this case in the US, and if an anti-suit injunction is capable of being granted, there seems to be no reason why an anti-suit injunction should not be granted in appropriate circumstances. These two cases suggest that the European Court's antipathy to anti-suit relief is not necessarily shared at the member state level, where in Germany and France at least, a degree of sympathy with the Anglo-Saxon approach to restraining foreign proceedings is detectable. The return of anti-suit injunctions in the EU context is particularly significant because the likelihood of parallel proceedings in the UK and within the EU has increased as a result of Brexit. To state the obvious, the recast regulation will continue to apply within the EU, where the defendant is domiciled in an EU member state. That will be so where there is an exclusive jurisdiction clause in favour of the English court, subject to the Hague Convention. Pre-Brexit, such a clause would have enjoyed particular weight under the recast regulation. Article 25 permits the parties to agree that the court of the member state has jurisdiction, thereby enabling the parties to trump the other bases for founding jurisdiction, such as the defendant's place of domicile or the place of performance. Now, assuming one has a valid exclusive jurisdiction clause, the mandatory stay provisions of Article 31(2) kick in. This provision means that where there are parallel proceedings in the courts of two or more member states, both in the parties' chosen court and in a court not chosen, the court not chosen is obliged to stay its proceedings, whether or not it was first seized. However, Article 31(2) only gives priority to the parties' chosen court if it is within the EU. Where the chosen court is a third state, a much weaker lis pendens regime is likely to apply under Articles 33 and 34. Those provisions, instead of imposing a mandatory stay, give the member state courts a discretion to stay proceedings in favour of third state proceedings that are related or involve the same cause of action and the same parties. The discretion to impose a stay is only exercisable if certain criteria are met. For example, proceedings in the third state need to have been started first, and the judgments of the third state must be capable of recognition and enforcement in the member state court considering whether to grant a stay. Conversely, member state courts can opt to continue parallel proceedings if, for instance, the proceedings in the third state are unlikely to be concluded within a reasonable time, or the continuation of proceedings before a member state court is required for the proper administration of justice. So any English proceedings commenced in reliance on an English exclusive jurisdiction clause will not enjoy priority by default over parallel proceedings within the EU under the recast regulation. There may be an issue as to whether the Hague Convention applies so as to oblige a member state court to suspend or dismiss proceedings, but that will turn on the controversy as to when the convention started to apply to the UK in its own right. Let's end with an illustration of how the recast regulation might operate in relation to a pre-convention contract. Imagine a dispute arising out of a contract between French and German companies. The contractual place of performance is Germany. The contract also contains an English exclusive jurisdiction clause whose validity is disputed. Now, if, for the sake of argument, the French company complains that the German company has not performed, the German party might seek a declaration of non-liability in Germany and race to commence such proceedings first in time to ensure there's no prospect of a stay under Articles 33 or 34 in favour of any English proceedings started by the French company, whereas the French company may wish to commence English proceedings first in time to preserve the possibility of any German proceedings being stayed. Query whether the German company might wish to seek an anti-suit injunction to restrain the English proceedings. Ironically, therefore, the flip side of anti-suit injunctions becoming newly available to impede EU proceedings is the increased risk of and incentive for parallel proceedings within the EU. And if the English courts have taken back control over their ability to enjoin proceedings within the EU, we might also see an increased willingness on the part of courts within the EU to grant anti-suits to scupper actions in this jurisdiction. So we might discover that the return of anti-suit injunctions ends up being double-edged. Now that concludes the formal part of the webinar, so it remains for me to open the floor up to any questions.
Fantastic. Now, we've had a flood of questions. We're going to take 10 minutes and try and get through as many of them as possible. So starting off first, a question for you, I think, Simon. Article 2.2 you mentioned has the exclusion for carriage of passengers and goods. Where does that leave us in terms of charter parties, time charters and voyage charters? What do you think the answer to that is?
It's a very interesting question. The general rule is that all marine contracts and shipping law areas will be covered unless they're specifically excluded. see the notes I put up in the slide. Article 22F only excludes contracts for the carriage of passengers and goods. Other contracts, therefore shipping contracts, are covered. A time charter party, although the time charter vessel is of course used for the carriage of goods, is not a contract for the carriage of goods. It's a contract for the use of a vessel where the owner provides the services of his vessel to the time charter. So I think that's easy, that's within. Voyage charter, rather more difficult, because the voyage charter is usually a contract entered into by the voyage charterer for the carriage of goods, which he usually owns or is just about to sell, from place A to place B. And that, I think, is much closer to a contract for the carriage of goods. But I wonder whether, looking at the way in which Professors Hartley and Dogauchi have tackled it, that they're looking at contracts of carriage of goods which are covered by conventions. Now, of course, the Hague Rules and the Hague-Visby Rules only cover contracts of carriage of goods subject to bills of lading. They don't cover contracts subject to voyage charters. So I think there's an interesting debate there. I mean, you could say, well, yes, the goods are being carried, but I'm engaging the services of a vessel for a service. I can actually ask it to go empty from A to B. It just happens to have cargo on board. I think that's a slightly unrealistic view. So I think that's really quite an interesting question.
Yeah, I agree. For exactly the reasons you've given, I think that the simple approach under the Hague Convention is attractive in one sense, but it doesn't really deal with those sort of areas. And what it doesn't, I think, is consider the ways in which different jurisdictions look at different types of contracts and how they characterise them. For example, as you say, is a voyage charter a contract for the carriage of goods or not? So I think that one is going to throw up, as you say, some interesting questions. That brings me on to another question that somebody has asked. Presumably allocation of jurisdiction under existing conventions, for example, the CMR still applies. Well, the CMR would be covered under the carriage of passengers and goods. But do we take it from the exclusions list that has been intended to cover existing conventions? So there shouldn't be overlap, or is there scope for overlap, do you think?
No, I don't think there is overlap. I mean, contracts of carriage for passengers and goods, as the explanatory note says, by road, rail, sea and air. By road, there's not much difficulty. It's definitely a contract for carriage of goods if you're taking goods from Huddersfield to Rome. And one can see there the reasoning for excluding a jurisdiction convention scope from a particular type of carriage, because the CMR does have jurisdiction provisions in. And so those, I think, will definitely be unaffected. And I don't know whether that was in the mind of the drafters, thinking, well, the CMR's got it in, and other type of rail conventions have it in. So let's take all transport out, or carriage of goods out rather than transport, and make it accordingly. But I think where a convention actually applies its own jurisdiction rules, those rules continue to apply. They continue to apply because if it's carriage of goods, this convention doesn't apply.
Rob, a question for you. The fascinating wording which you touched on of Rule 6.33 2B, that where a contract contains a term to the effect that the court will have jurisdiction, you don't need permission to serve out. Now, as you said, that's some pretty broad wording there. Question is, do you think that is going to effectively scoop up anything that isn't caught by the Hague Convention? So as Simon says, asymmetric clauses are probably out. Do you think that provision of the CPR is going to encapsulate anything that doesn't quite meet the criteria of the Hague Convention?
That seems to me to be the intention. I mean, it is obviously sensible that those contracts which fall outside the Hague Convention, which have been described, are dealt with expressly, and that wording, a term to the effect that the court shall have jurisdiction, was obviously chosen for a reason, and it does seem to me to be an attempt at least to scoop up, as you say, anything that falls outside the Hague Convention and to bring it within that provision. As I say, the question I think is how far it'll extend beyond maybe clauses which expressly refer to matters being referred to, whether it will get a wider meaning than that, and actually therefore extend the scope beyond what others might have thought. But it does seem to me that was the intention of that clause, and it'll be fascinating to see how it develops in in the court's case law in the years to come.
Yeah, I think it's probably going to give rise to some quite potentially inventive arguments and keep us all very busy. Okay, this question I'll throw open. Is it right that the Hague Convention applies to all English exclusive jurisdiction agreements, provided that they fall within the scope of the Hague Convention, regardless of the rival jurisdiction? So does it matter if somebody turns up and says, well, actually, the French court ought to take jurisdiction, or the US court ought to take jurisdiction? Does it matter? Is it enough that the choice of court agreement says England? Does anyone want to take that, or I'm happy to?
Well, I think so. If I volunteer an answer and the others can shoot me down, but the wording of Article 5 is the Court of Courts of a contracting state designated in an exclusive choice of court agreement shall have jurisdiction. So that's now part of English law. So if on this hypothesis the English courts are designated within Article 3, it seems to be the answer to that is yes.
Yes, I think that's right for what it's worth. But just to note, contrast the position under Article 6, which sets out what you have to do in terms of declining a jurisdiction. Now that applies only where the choice of court agreement is in favour of another contracting state. Yeah. So there isn't a mirror image there. So I think that one's important to recognise. Now, a question for Andrew, in respect of the Turner and Grovitt case and the Francomo, with which we're all very familiar. Now, does that form part of retained EU law? Because obviously there is certain EU law which is retained, quite a lot of it. Is there any argument that would still apply?
I think the answer at the moment is probably not. Now, retained EU law is a snapshot of EU law, including relevant EU decisions, as it stood at the end of 2020. And all of that was grafted onto domestic law when we Brexited. So the question is whether Turner and Grovitt and the Francomo are relevant EU law. It seems to me the answer must be no, at least at the moment, because the Brussels regime only applies as between member states, and we haven't acceded to the Lugano Convention. Now, should we eventually be allowed to accede to the Lugano Convention, I suspect the answer would change and they would be relevant EU decisions and we would have to apply them. But for the time being, I think the answer is no.
Okay, thank you, that's helpful. Simon, one question's come in relation to insurance contracts and then the declarations made by the European Union and the UK as to what scope of insurance contracts they think consider. Can you reply? Can you shed a little bit of light on that for us, please?
Yes, I can. I think the slides went a little too fast. Let me share screen again and see and just put up a slide, which I think is what the questioner is asking about. Right. So the slide before, I referred to Article 17. And as I said, Article 17 includes all contracts of insurance, whatever the risk insured, notwithstanding the risk insured is something excluded from the scope of the application of the Convention. I omitted, by speed, by going over this slide, to point out that insurance is still pretty widely covered. But when the EU acceded in 2015, it made a reservation excluding all insurance except the insurance that was specifically included. Now, for heavy insurance practitioners, they will look down the list and think, well, this really covers all insurance. All contracts of reinsurance are covered by the EU reservation. Insurance of marine and transport risks, a long definition, but that's in essence what it says. Insurance contracts where the insurer and the insured are in the same jurisdiction as the court which they pick, as having exclusive jurisdiction, other specified risks, and what I call there, in summary, big business insurance, where there's a particular turnover or balance sheet or number of employees to satisfy. So I'll just stop sharing, come back. So I think the moral is that when you're looking for insurance contracts, you've got to read Article 17 on the one hand and look at the reservations on the other.
Because the reservations of the EU and the UK are slightly different, is that right?
Slightly different. So one's got to think. One's then got that temporal difficulty which we had before, which I talked about at the beginning of the first question, which you sent me, and you've then got to balance the EU's reservation covering the period up to 2020 and then our reservation, which we lodged in 2020, they're pretty similar.
Okay, thank you. That's very helpful.
Gemma, can I ask you a question?
Oh, yes, please do. Yes.
Right, so what if proceedings were started in France under the Brussels regulation in 2020,
yep,
and the defendant comes to the English court and commences proceedings here now? What jurisdictional rules do you think the English court will apply?
Right, well, that's a good question. That's why I put on the slide sort of note that in respect of proceedings which were started before the completion date, so before 31st of December 2020, the Brussels rules still apply. Now, this is actually covered in the withdrawal agreement, Article 67, I think is right. And there, it's not entirely clear, but it does look as though the rules on lease pendens, so court first sees those rules, even where the proceedings are instituted in a member state, they don't have to be instituted here. If proceedings are instituted in a member state before the 31st of December 2020, and an issue relating to those proceedings occurs here, then you still have to apply the Brussels recast. So it isn't crystal clear from the withdrawal agreement, but I think that is most likely to be the answer, or at least most likely to be the intention of what was put in the withdrawal agreement. So I hope that answers the question. Right, I will wrap up with one very quick question. Finally, does any of this have any effect on agreements to arbitrate? I will throw that one open to the floor.
Shall I have a go?
No.
I was going to give the same monosyllabic answer.
Yes, I was hoping for a resounding no, no from all parts. No is the answer to that question. There is no effect. Though query what will happen in an interesting contract, which you do get sometimes, where there are provisions providing for arbitration in some circumstances and exclusive jurisdiction in the other. That's a question that will probably keep us all hopefully busy for some time to come. So it just remains for me to thank the panel and for everybody who watched. We will be sending around a handout with all the slides on, which hopefully will be of assistance in the coming months and perhaps even years. If you would like to join us now for a Q&A session, we will be doing that on Zoom, and you should have been sent a link to that as a participant. So it just remains me to thank you all very much for watching on behalf of the Quadrant team.